So again, welcome to Safeguarding Your Succession, Family Law and Estate Planning Fundamentals. We're joined today, we have the honor of being joined today by family law attorney Akilah Harris-Small. We'll give her the floor to introduce herself in a little bit and tell us about her background and her experience. And we are Lauren Klein and Kristen Landon of Flourish Law Group. For the next 50 minutes, we're going to be explaining to you all about the important family law and estate planning fundamentals that everyone should know in Florida, but especially if you are getting married, going through a divorce, or are divorced, growing your family, or have a blended family. And just quick, boring legal disclaimer, this presentation does not create an attorney-client relationship. We are not providing legal advice or opinions. We are simply talking about important things that you should know. And if you have any questions or wish to be represented, of course, let us know. And really, before we dive in, why are we here? Why did you sign up for this? What is the intersection of family law and estate planning? It's two different areas of law that are governed often by two completely, separate parts of Florida statute. But there are so many times that these areas of law intermingle. That's the reason we got together today to present this information to you and to really give you some good perspective and education on this. So we're going to be talking about different things. What is family law, paternity, time sharing, parenting plans, pre and post-nuptial agreements, a quick overview of estate planning fundamentals, rights of surviving spouses, and how does a divorce impact, if you pass away or become incapacitated either during the divorce or after, and just some tips about updating your estate plan after major life events. Turn it over to Kristen to introduce herself.
Hi, my name is Kristen Landon. I'm a co-owner of Flourish Law Group with Lauren Klein. We started the firm about a year ago, but we both have over 10 years experience working in trust and estates. I worked as a corporate trustee for a wealth management firm, and I also did estate settlement, which is where the bank was acting as trustee and personal representative for our wealthy clients. And we kind of left those corporate jobs and started working in our own firm so we can help everyday families and really spread education. So, and Lauren, I'll turn it over to you so you can introduce yourself.
Kind of said it better. So all, ditto, all the same things that Kristen just said. My background is similar, but a little different. I spent most of my career in one of the largest private wealth services groups in a law firm, working with high net worth families on estate planning and tax planning. So Kristen and I really combined our knowledge and experience to make sure that every family, not just the high net worth families of the world, have this expertise and this education so we can protect everyone's legacy and everyone's planning. And just on a personal note, I live in Fort Lauderdale with my husband, and I have two little boys, ages 3 and 1. And now I'll turn it over to Akilah. Oh, and I'm sorry, I deleted some of it. Oh no, I can either recap that or if you just want to give an intro of yourself.
That's okay. I think I can talk about myself for a second. So thank you for having me. A little bit about me. My name is Akilah Harris. I'm a family law attorney. My practice is in the Tri-County area, but my offices are located in Broward County. We have one office in Fort Lauderdale, close to the courthouse, and then we have one in Pembroke Pines, Florida. I've been practicing family law for coming up on 10 years next month. I'm originally from Brooklyn, New York. I've been in South Florida for, quite some time. Let's just leave that there. I'm not going to date myself. I went to undergrad at FAU. I got my bachelor's in criminal justice and a certificate in women's studies. I went to graduate school. I got my master's from Nova Southeastern in criminal justice. And then I went to law school at Nova, so go Sharks. I passed the bar and was admitted in 2013. So like I said, I've been doing this for quite some time. I'm also a trained guardian ad litem, and I've been doing guardian ad litem work since before I got admitted to the bar. So that's that for me.
Definitely need people to do that. That's a great job.
Yeah. I didn't realize that. Oh, there it is. There it is. It's just a fancier slide. Look at that.
Fancy transition.
Okay. So what is family law? Family law is pretty much anything that has to do with the family. You guessed it. So it covers divorce, time sharing, child support, adoptions, prenuptial and postnuptial agreements, paternity actions. It's very extensive. Anything under the domestic violence arena falls under family law. But today we're just going to limit our discussions to the crossroads between family law and estate planning, which would be paternity, time sharing, postnups, and prenups. So we'll get into it. As far as paternity is concerned, um, it's when you have children born out of wedlock and the parties are not married. There has to be an establishment of paternity for the father in order for the legal rights to be established. So you or a father can file a court case with the circuit courts to establish his paternity rights. The mother of the child can also file the case to establish not only the father's paternity rights, but also rights to child support and time sharing for both parties. Or the parties can establish paternity by affidavit of acknowledgement, as long as it's signed by both parties and filed with the courts. And they can also do the same thing with a stipulation. So there's a few different ways that paternity can be established. So recently we had a statute change last summer in July. So the paternity statute originally only spoke to unwed mothers, and it gave mothers complete legal rights and complete access and control and custody of the child or children that was born out of wedlock. But since the change last summer, it names both the mother and the father of the child or children the natural guardians of the child. And all that means is that with the statute change, unwed mothers don't have 100% control of the situation anymore. The way the statute was written before, fathers were at a little bit of a disadvantage because mothers were naturally given all the legal rights and to their children. They could enroll the children in school and make all the medical decisions. And in some cases, they could even relocate without the father's permission. So now with the statute change, naming both fathers and mothers of children natural guardians, it kind of levels the playing field to say that both parents need to be involved from the very beginning in the inception of these children. Both parents need to be involved and are legally recognized as parents of the child. So with paternity actions, a huge misconception is that you have to have a DNA test. That is not the case. Unfortunately, the paternity action is just a name. If there happens to be a question about the biological father and who that may be, then the mother or the father can request a DNA test be done, but just because a paternity action is filed does not necessarily mean that a genetic DNA test needs to be done. So once paternity is established by one of those means that I mentioned previously, the legal rights are then established for the child and for the mother and the father. So that gives the child the right to their family medical history, that gives the child the right to know, obviously, the identity of both of their parents. The father's name will be added to the birth certificate. Health insurance, life insurance from either parent, if available, would now be a benefit available to the child. Support from both parents, aka child support, and also medical support. So having medical insurance obviously is important and very costly. And then any social security benefits or veteran benefits, military allowances, and inheritances that would be available to the child now that we have paternity established for their parents. So segueing into time sharing, prior to 2008, we used to refer to time sharing as custody of the child. Florida was the first state actually to change the language. So if you hear anyone refer to, the custody of the child, or it's legally incorrect, we call it time sharing these days. Um, and it was a whole revamp of the statute. They had to go through and literally take out the word custody in all places. So time sharing is pretty much just what it sounds like. Who's going to spend their time and how the child's time is going to be spent with both parents. Parental responsibility also goes hand in hand with time sharing. And parental responsibility is just a fancy way of saying who's going to be responsible for making the major decisions regarding the child. Florida law usually likes to award what's called shared parental responsibility, meaning both parents have the right to make decisions regarding the child. If the court does anything different than shared parental responsibility, maybe they give one parent, ultimate decision making, or they give one parent sole decision making, there has to be a showing that shared parental responsibility would be detrimental to the child. Um, and just some other, commonly known names. Like I said, you'll hear custody still used by certain individuals who probably aren't in the family law arena. But you'll hear time sharing referred to as parenting time, visitation, or possession of the child. Um, when it comes to the parental responsibility and the time sharing, all that is wrapped up into what we call a parenting plan. So the parents, if there are any attorneys involved, or the courts, get together and draft a parenting plan agreement, which is a living, breathing document that explains everything in regards to rights and responsibilities and decision making for the parents and the child. Parenting plans are not a one size fits all document. They're very customizable to families and their individual situations. Not all families are the same or created equal. So if you have a special needs child, or there are any other components that are just specific to your family, they would all be thrown into the parenting plan, that the parents would then use that as their guide. If they have any questions about anything legally related to the child, they'd usually be found in the parenting plan. So there are some requirements when it comes to parenting plans. There's some things that have to be in every parenting plan, and then you've got things that should be in there or maybe in there, but they're optional. So as far as what's required in a parenting plan, the parental responsibility that I discussed earlier, who's pretty much going to take care of the child and the day-to-day tasks and activities. The time sharing schedule absolutely needs to be in all parenting plans, and that'll tell you on what days the child is going to spend the overnights or day visits or whatever the case may be with which parent. And it gets even specific down to the minute. If the child needs to be picked up at 1:45 from school by mom on Mondays, all that stuff would be in the parenting plan. Decision making for healthcare, school related matters, including school boundary determinations and registrations, mental health treatment, methods of communication between the parents and the child. So whether they're going to be having FaceTime calls with the child, or regular phone calls, or Zoom calls, or whatever the case may be, all methods of communication between the parents and the child will be outlined in the parenting plan. And extracurricular activities, how they'll be handled, who's going to register the child, who's driving the children back and forth from extracurricular activities, how the costs will be paid or split between the parents, anything surrounding any extracurricular activities will definitely need to be in the parenting plan. And as far as optional stuff, or I like to have all these things in all of my parenting plans. It just makes it easier for the parents later on down the line. I include things like travel, If one parent wants to take the child out of state or out of the country, how is that going to look? Is there a notification period? Does dad need to email mom the itinerary 2 weeks in advance to explain, what countries and cities they're going to be visiting, where they're going to be staying, how they can be reached, who's going to hold the passport when it's not in use? Anything travel related, I like to include in the parenting plans, like I said, because the more you put into the parenting plans, the less often the parents have to come back to you to ask questions or modify, or to court to litigate. So it's best, I find it best practice to throw as much into the parenting plan as possible. Other things like transportation of the child. If the parties live 3 hours away from each other, or they live, 20,000 miles away from each other, how the child's going to get back and forth between both houses is important. So we'd have to outline the transportation of the child in there. How to deal with future issues. Like I said, this is a living, breathing document, and the thought process behind the parenting plan is that it will follow the family through the age of majority of the child till they turn 18, or graduate high school. But life happens, things change. Sometimes the parenting plan will either need to be amended, or it missing something, or something came up after the fact that wasn't thought of at the time the parenting plan was drafted, and disputes arise between the parents. So how to deal with these future disputes, whether the parents need to go back to court immediately, or they need to attend mediation, or they need to contact the parenting coordinator. However we see fit at the time to deal with any potential future disputes between the parents, I like to include in the parenting plan. And childcare. Childcare is a huge, huge, huge topic that, although it's not required to be in a parenting plan, I make it best practice that we include it, just because everyone wants to know who's going to be caring for the child. Is the child going to daycare? How the daycare is getting paid? If it's going to be a babysitter type situation, is it, grandma and grandpa? Is it, the neighbor? Is it, uncles and aunts? Whatever the case may be, childcare always becomes a hot topic. And again, I make it another best practice to make sure that all childcare related scenarios are included in the parenting plan. So along with the paternity statute change that we had last summer, we also had a time sharing statute change last summer as well. So now the statute gives a rebuttable presumption that equal time sharing, or 50-50, is in the best interest of all children. It does give you language where and how to rebut the presumption, and what the parties need to show if they feel as if 50-50 is not in the child's best interest. But absent a rebuttable presumption, the courts are leaning more towards 50-50 time sharing for all parties, or for both parents involved. So we can transition into pre and postnuptial agreements. Entering into marriage is a life-changing event, and no one hopes that they're going to get divorced, but it's best to, plan for the worst and make sure that it's within your control what happens to your assets and debts and liabilities, as best as possible, to A, limit the stress, and B, just to make it a very smooth transition. If divorce, or even in the event of death, everyone knows what's going to happen with anything as far as marital assets, liabilities, and that type of thing. So prenups and postnups are the best avenue to accomplish a very stress-free, amicable, divorce if necessary, or in the event of death of one of the spouses. The American Psychological Association reports that 40 to 50% of first-time marriages end in divorce. And further, the divorce rate is even higher for second and third marriages. So obviously, it's something that happens more often than we would like, but like I said, postnups and prenups are a good avenue to make sure that in the event of divorce, all your assets and liabilities are taken care of, and that's one less thing that needs to be worried about or even litigated at that point. So it gives couples peace of mind that while everyone is on a good page or a good note on the same page, they can make joint decisions as to how their assets and liabilities will be handled. So as far as premarital agreements, they're obviously legal documents, and they need to be executed and drafted in a certain way. There are a lot of requirements that go into these type of things to make sure that they're upheld and considered valid when it comes time to actually implement them. They must be in writing. They have to be legally signed by both parties. The legal signing is also a whole situation in itself. Some people like to have, well, they need to be witnessed. They need to be notarized just to make sure that certain protections are in place when you have a notary involved. They check ID and they make sure that no one's under duress or entering into anything that is against their will and everything's done voluntarily. Obviously, the next requirement is that they're voluntarily created. Prenups and postnups need to be a culmination of both parties' wants and desires when it comes to how to handle their marital assets and liabilities. And we want to make sure that all the information in there is truthful. So there's also a discovery phase that both parties need to go through as far as gathering all their financial documents and exchanging the financial documents so everyone knows what's on the table and they're not agreeing to anything that is untrue or that they didn't know about or anything of that sort. Postnups and prenups are very similar. The only difference is that prenuptial agreements are created and signed and entered into before the marriage takes place. Best practice is about 6 months before the wedding date. And postnuptial agreements take place after the parties have already been married for however length of time. There's no real best practice or rule that says there needs to be married for a certain amount of time and to a postnup. We can do it one day after the wedding, or we can do it 6 months after the wedding, whatever the parties see fit for them. Once both of those documents are signed and executed, they become effective. For the parties to be able to, use when necessary. Why couples should be choosing to enter into prenups and postnups, like I said before, it gives them a peace of mind that it's just one less thing that they need to worry about. It's an avenue that allows them to protect their assets. If they have blended families and they have children from other marriages that one party or another wants to make sure are taken care of properly, prenups and postnups, like I said, are the best way to handle that. It clarifies financial responsibilities, who's going to be paying the, household utilities, or who's going to be paying for, the party's travel expenses, or whatever the case may be. Addressing infidelity, obviously that's a hot button topic if it happens to come up in or during a marriage. And one spouse may be willing to dissolve a marriage amicably if they know that they're going to get alimony if the other spouse was unfaithful during the marriage. So those type of things can be built into either prenup or postnup. If either or both spouses are business owners, this is a way to protect the business interests. And then obviously for estate planning purposes, and I'm sure Lauren and Kristen will give you more information on how prenups and postnups kind of feed into what they do on their end with estate planning for their clients.
Awesome. That was really good. I learned a lot too. So thank you so much for all of that. That was amazing. And so now we'll turn it over to the estate planning side, but I think you'll see as we talk about it, there's going to be a lot of overlap in all those different topics that Akilah covered. So Kristen, I'll turn it over to you.
Thank you both. And I mean, as you were talking about prenups and postnups, they really are part of the overall estate plan. So it's very relevant that this would kind of be the next part of the conversation. It is an extension of financial planning and, just planning for the good, the bad. So it's super important that everybody, thinks about this, and not only thinks about it when they're older, because that's one question we get all the time, and it's something that I've really experienced with a lot of people is they say, it's something that I'll take care of later when I need to worry about it. But I think the peace of mind that it gives, and once you learn a little bit more about it, you realize how much value estate planning really gives you during your life. So some common goals of estate planning is just to make sure that the assets that you have, you can give them to who you want, everything that you have. A lot of people say, do I have an estate plan? And the reality is that everybody has an estate plan if they're living and breathing. We all have assets, we all have things, and we may not be thinking about it. So it's important to make sure that we know who those assets are going to in the event that something happens. The next thing is avoiding probate court. A lot of people aren't sure what probate is, but they know it's bad. They've seen it on TV or they've heard about it through a friend or family. And it can be a very public and expensive process, and making sure that you're laying out for your family members exactly who gets what and how they get it, and avoiding probate is really important. And we're going to tell you a little bit more about how to do that. Maximizing your asset distributions to your loved ones, caring and protecting for a surviving spouse or children, at your death. And maybe that's if you have an insurance policy or something, and you want to make sure you have guardrails set up to exactly how those assets are going out to those individuals, whether it's a spouse or children, especially if they're minor children. You can care for yourself during lifetime. This is usually if you have like a trust and you can set it up during your incapacity. You can have a trustee take care of your assets and make sure that they're paying bills, and you've really planned for that in advance. You can pass your values and ideals on to your children and grandchildren, and that's through certain provisions that you can put in your asset plan, your trust. Maybe you do certain rewards if children go to school or graduate or get married, and you can really kind of be very specific on how you want those documents to be laid out. You can protect your assets from creditors. We'll talk about that a little bit later, bankruptcy, and there's a lot of different ways that you can do special planning. And if you have a taxable estate, you can also protect it from that as well. So those are just some of the little quick items, and then we'll talk about them a little bit further. You've probably heard of some of the common estate planning documents, but we just kind of laid them out here: the last will and testament, a revocable living trust. We'll talk about a little bit more in detail what the difference is about those: a power of attorney, designation of healthcare surrogate, living will, declaration of preneed guardian, remembrance service, nomination of guardians for children, assignments of personal property, tangible personal property memo, and a irrevocable trust. And we'll talk about those a little bit more in the further slides about exactly what those are. So what is an estate? Like I said a little bit earlier, an estate is really everything you have: your bank accounts, checking accounts, your car, your brokerage accounts, your 401k, your home, your life insurance proceeds, any of your personal property, your jewelry, your handbags, your watches, intellectual property if you have it, if you've written a book or created music, or anything that would be kind of more personally created, and then your business interests. So, like Lauren and I and Akilah, we have our own businesses, and it's really important to make sure you have specific planning in place for those items. The next question is, well, I don't have an estate plan, or do you have an estate plan? And the reality is that everybody does have an estate plan. The state of Florida actually has an estate plan for you, and it's the default plan. So the state of Florida decides what all of your assets, where they're going to go, who's going to get them. And the reality is you may not like what those default rules are. So when you're doing estate planning, when you're creating a will or a trust, you're opting out of that default plan, and you're really taking ownership of those decisions, and you're deciding for yourself who you want your assets to go to. Typically, the default plan is going to look something like, I have a spouse and no children, everything goes to my spouse if I don't have a prenuptial agreement. If I have no spouse and I have children, those assets are going to go to my children. But sometimes that's not exactly the way we want it to flow. Sometimes we have minor children and they can't hold assets when they're minors. So there's a lot of reasons why it's important to make sure that you lay out your plan exactly how you want, so everything kind of flows the way that you want it to. So dying without a will or a trust is called dying intestate. And you may be in a situation, this might be the situation that a lot of people are in, especially depending on your age. I know our generation, a lot of people don't have estate plans. And this is kind of called the do nothing plan or the default plan that we just talked about. So, and then also something that you want to think about too is if you have minor children, and this is something that I think we talk about so many families and parents, it's something that they're really concerned about. Maybe they had children and they're thinking, oh, I want to take that first vacation without our babies or whatever that is. And so you want to really make sure that you're naming a guardian and you have allocated who's going to take care of your children if the very worst happens. We all hope nothing like that would ever happen, but I think that there's a lot of peace of mind that you can get knowing that you've already made that decision and you know who's going to take care of your children. If you don't have a guardianship named in your will, then a judge is going to choose for you who's going to be the guardian of your children. And it may not be the person that you would have decided to take care of your children. And there could actually be some fighting in between with different relatives that think that they're the one that you would have wanted. And you can really avoid a lot of that heartache if you make that decision and you make it really clear. It is somewhat of a extensive process. It costs money to go through that process, and you have to have a judge make that final determination. So there's a lot of little things that you can do to really make that determination yourself and have that decision already laid out. So what is probate court? The court, when you die without a will or with a will, you will have to hire an attorney. The court will appoint a personal representative. If you have a will, it'll usually be the person that is named in the will that will be petitioning the court to be named as the personal representative. They'll publish notice to creditors in the paper saying, hey, does anybody owe money, or is money owed by this individual? If so, come forth and you better make a claim. And if you don't make a claim within a certain amount of time, those claims are barred. You have to file an inventory. You have to distribute assets to the individuals. Everything is reported in public, and it's filed within the clerk of court. So really anybody can go and look at your will and look at what the inventory is and different assets. And you need permission from the court to distribute anything out to those beneficiaries. And you do have to hire an estate lawyer or pay legal fees, and that's something if you do the proper planning on the front end, you can save a lot of money and heartache. And the fees that a lot of attorneys will charge either a flat fee or a percentage of your estate, and that percentage can be anywhere from 3% to 7% of your overall assets, excluding your homestead. So that can really be a lot of money if you think about the assets that you have. So it's just so important that if you do the right planning, you can kind of avoid those fees on the back end, and those assets will go to your children. So the downside of probate is it's expensive, it's time consuming, and it's a public process. It can take between 6 to 9 months to 2 years, depending on how many assets and what type of assets that you have. And if you have a taxable estate and you have to file an estate tax return, then it's probably going to take, closer to that 2-year mark to get everything back from the IRS, and whether they do an audit of your tax return, you'll just keep waiting for them to release that. And so we already talked about the fees, the 2 to 7%, and often those assets can be frozen during the process of probate. So if there's a bank account that is paying for a mortgage, and it's really important that you have access to those assets to be able to continue to pay the mortgage and the light bill and everything. If you haven't done any proper planning, you have to wait for the probate court to open up that account and have the personal representative become involved. Otherwise, the bank, once you notify them that that individual has passed away, they freeze that account and nobody can get in. A lot of people have a misconception that you can use your power of attorney to get into that account, but once that individual has passed away, that power of attorney is no longer valid. Okay, so now you've just determined that you need an estate plan. I just, gave you all this scary information about what happens if you don't have one. Now you get to determine what type of estate plan that you have, and you have a couple different options. So the options are the will-based plan or the trust plan. You can either do kind of the will. It's important. It's really good to have, but it's a little bit more of the bare minimum, where you are naming who you want to get different items, but it doesn't mean that you're avoiding probate, and it doesn't mean that you're necessarily avoiding those fees. So sometimes the better option is the trust. But a will, if you're going to have anything at all, you should at least have a will to make sure you're naming who you want to receive your assets, and also making sure that you're naming a guardian for your minor children. The trust-based plan means that you're going to kind of be able to curate and have that be a living document, and you get to avoid probate if you create the trust. So we'll talk a little bit more about that. And then in the next, I want one before. So the last will and testament is better than nothing. You get to nominate guardians. I guess I said all this. Beneficiaries and the personal representative will also be named in the will, and they're the ones that's going to wrap up your estate. They're going to pay any final invoices or bills that you have. They're going to file any final tax returns that you need to, and once the probate is closed, then they're going to close that out and distribute those assets out to your beneficiaries. The revocable living trust is the second option. You get to create and fund the trust during your lifetime, and that's the document that you can also have benefit you during your lifetime. As you age or become incapacitated, you can kind of hand that responsibility off to another trustee, and they can kind of take over and pay your bills and manage your finances. You get to avoid the probate process completely if everything is named and funded specifically in your trust. You don't have to go through that process because you've already created a separate vehicle that is going to hold your assets. You get to nominate beneficiaries for your assets just like you can in a will, and you can create different contingencies on how those assets are fed to those beneficiaries over time. So you could say, I just want to make sure there are certain standards called ascertainable standards where your beneficiaries, if they have a resulting trust, might get funds for health, maintenance, and support, or maybe education, different things. You can kind of say very specifically, I want my children to benefit from the proceeds of my life insurance in this very specific way, but I really want to make sure that these assets are going to span a longer portion of their life than maybe if they would have received those assets outright. Let's say you have an 18-year-old child and they just get a windfall of money from an inheritance or a life insurance policy. At 18, what would have I done with $100,000 or $500,000? Would have I dealt with those funds in a really responsible way? Maybe. It really depends on the child, but I think a lot of parents want to make sure that they have somebody else watching over, because 18 might feel like an adult, but I have some friends that have 18-year-olds and they're still babies to me. I can't even believe it. And I always wonder, did I look like that when I was 18? So,
Yep.
and you can make it revocable, which means that you can make changes over time. If you name specific beneficiaries, you can make changes. If you have specific provisions, you can change those as you age, as your children grow, as your circumstances change. And you're the trustee during your lifetime, so you have full control over these assets. You're not relinquishing control. You're not giving it to someone else. It's really just a vehicle that helps you avoid probate and save money. And so I'm going to kind of turn the next slides over to Lauren, and she's going to talk a little bit more about estate planning during and after a divorce and kind of bring it full circle with a lot of the information that Akilah gave us earlier.
Awesome. Thank you, Kristen. Yeah, so I'm going to kind of tie it all together. Akilah talked a lot about some really, really helpful things to know about if you are going through a divorce or if you're dealing with paternity issues or, time sharing. And all of that really does tie into estate planning in so many ways, prenuptial agreements. One of the biggest things that we see when we're working with clients with respect to a prenuptial agreement are the rights, the estate planning rights that you have before you're married, once you get married, and then during and after divorce. So the things that you're looking at from an estate planning perspective when it comes to a prenuptial agreement or a postnuptial agreement are those spousal rights that you have in the state of Florida. And some of the most common ones are the elective share, which essentially says that if there is a surviving spouse, they can make a claim of at least 30%. Up to 30% of your estate. And there's ways that, that's configured and determined under Florida law, but that is a right that a surviving spouse has. It's so, unless the surviving spouse has waived that right to an elective share in a pre or postnuptial agreement, it's public policy right to protect a surviving spouse. There's also homestead rights. So let's say, there's a married couple, but the property is only in one person's name. If they pass away, unless there's, again, a prenuptial agreement or a postnuptial agreement, you can't just kick that surviving spouse out of the house if he or she wasn't on the title. They have the right to either take a life estate, meaning they can live in the property during life, or they can take what's known as a tenants in common interest, with any children who have survived, adult children who have survived. There's also the laws that Kristen talked about that default intestate laws. And so if you haven't, done a prenuptial agreement or postnuptial agreement, and if you haven't done an estate plan, then your surviving spouse might get everything, or it might be adult children, depending on, whether you're a blended family or not. And so these are just all the things to start to think about. And it's, entering into a prenuptial agreement, I think the stigma is getting a little bit better. For years, I think it meant like you're basically saying we might get divorced and, I don't trust you. And it's not that at all. It's saying I want to have ownership over what I do with my assets, especially now that people are getting married a lot older. I want to do what I want with my assets. I may still decide to give everything to my spouse, from an estate planning context, but I don't want to have to be required to do that. Maybe you each brought assets into the marriage. So those are just some of the things to think about when you talk about that overlap of family law and estate planning. So something that I've seen over the years a lot when I've seen couples, in the process of divorce, there are oftentimes one of the spouses could become incapacitated, whether the couple, maybe they're older and one of them, starts to show signs of dementia, or something else happens where there is a capacity issue. That can be really scary, right? If you are saying, okay, I am divorcing this person, and maybe it's amicable, but maybe it's not. I'm sure Akilah can attest to the fact that more often than not, it's not an amicable divorce. So if you don't update your estate planning documents during that time that the divorce is pending, then the decision maker will be determined by your documents. And that could be your spouse, and that could be really scary if you're in this bad situation and now they're making decisions on your behalf. So Florida law has kind of set in place some rules about what happens if one of the spouses becomes incapacitated, during this time period. So with respect to power of attorney, so that's one of the documents that Kristen touched on to allow someone to make financial decisions on your behalf if you are incapacitated. If you have named a spouse as that agent in that power of attorney, Florida law now provides, unless the document says otherwise, that power is automatically terminated upon the filing of a petition to dissolve the marriage. So that's a benefit, unless you say, I would still want them to be my power of attorney. You really don't want a soon-to-be ex-spouse being able to move money out of your accounts and things like that. In Florida, we have what's known as a durable power of attorney, so it's effective upon signature. You don't have to show, no one has to show that you are incapacitated. So something important to think about. Now, healthcare is a little bit different. So healthcare cert, if you're in the process of a divorce and you become incapacitated, then that designation is effective until revoked. terminated or upon the entry of a final judgment of dissolution of marriage. So that's a little scary. You know, if you're in the process of a divorce or thinking about getting a divorce, you might want to consider updating, you know, these documents, especially healthcare documents, like a living will. That's if, you know, you can designate who will make life prolonging decisions, whether, you know, I hate to say it this way, but pull the plug or not. You know, you may not want that soon-to-be ex-spouse with a lot of animosity saying, pull the plug, just do it. You know, those are some things to think about that can be really important. Even if you're just considering getting a divorce, talking to, you know, your family law attorney, talking to your estate planning attorney, or both, ideally, on, you know, what steps can you take before you even file for that divorce, or before something, you know, inadvertent happens during that process. Now, when we're talking about assets and who's going to be getting assets, this is also important. If you file for a divorce and you have that soon-to-be ex-spouse named as a trustee of the trust, and let's say the document doesn't affect what happens, you know, doesn't say what happens in the event of a divorce. We always ask our clients, okay, if you get divorced, what would you want to happen? In that sense, that spouse may still be able to serve as trustee, so they may be able to move money, especially if they become incapacitated. Again, that can be really scary. And they may still be considered the beneficiary of the trust. And, you know, sometimes there can be issues with changing those documents during the divorce. So things to think about: talking to a qualified family law and or estate planning attorney, or ideally both, on, okay, here's what I'm planning to do. What are my rights? What can I change? And what can I do throughout this whole process? And same thing with last will and testament. You know, who's going to be serving as the PR if something happens to you? And again, if you don't have a trust, who's going to be benefiting? Treatment of decedent's remains. I have actually seen issues with this over the years, where there is a divorce pending and someone passes away, and there can be a huge disagreement and dispute over what's going to happen and who has control over those things. So really important things to think about. We work very hard for our money, and if we are going through a divorce or thinking about going through a divorce, things that you really want to think about. Also, you know, pay on death or transfer on death. Kristen talked a lot about probate and ways to avoid probate. Sometimes, you know, it's a payable on death, a designation on a bank account, transfer on death on a brokerage account, making sure that, you know, you're updating that if you pass away during the divorce, because again, unless you change it, and you may not be able to change it sometimes during the pendency of the divorce, you know, making sure that that reflects who you would want to receive those assets. I have seen that, you know, time and time again. Someone is either, you know, about to get divorced, and the surviving children say, oh my gosh, you know, mom or dad definitely would have wanted me to get those assets, not, you know, other parent or step parent, whatever it is. And it's heartbreaking when you see families not receiving assets that, you know, that decedent would have wanted them to get. Also something to think about: if you own jointly titled assets, looking into how are they titled, how are they owned, and whether, you know, talking to your family law attorney during that divorce, and even bringing in the estate planning attorney in the divorce proceedings to make sure that the title does reflect what you want upon the dissolution of marriage, and how that affects you. You know, tenants by the entireties is an ownership interest, where that's specifically between spouses, where assets pass to the survivor by operation of law, versus tenants in common, where each person, you know, can dictate what happens with their assets. Making sure that you understand what those terms mean and how that affects the flow of assets. And again, you know, if it's happening during the divorce, that intestate share is going to kick in, like Kristen talked about, and then that homestead issue as well. Now, after the divorce, things are a little different. Florida does have some protections in place. So under a last will and testament, Florida law provides that if there's a divorce, then that surviving former spouse is treated as if they had predeceased. And so that is helpful. And that's a change that Florida made to make sure that, you know, surviving ex-spouses are not just receiving assets. Also, dissolution of marriage, the effect on a revocable trust. And again, you can always opt out of these or put specific language in your trust. But if the trust is executed by a husband and wife prior to the annulment of the marriage or the entry of a judgment for dissolution, then any provision of that trust that affects the seller spouse will become void. Now, you might think, okay, so then I don't have to have my estate planning documents reviewed after a divorce. Do not fall prey to that false sense of comfort, you want to make sure that you know what all those other terms are in that document to make sure that there isn't an exception and that everything is going exactly the way that you would want it to go and to the people that you would want to receive your hard-earned money, your inheritance that you've received from others, your business interests. Really, really important. Now, big warning here, if you have an irrevocable trust, like Kristen mentioned, there's a really common planning technique known as a SLAT, or a spousal lifetime access trust. It's a way for high net worth individuals to get assets out of their estate, but still allow their spouse to benefit, and then they can indirectly benefit potentially. And unofficially, it's a very common technique. I've done many SLATs over the years, but there are major downsides. I actually got a call recently from a financial advisor. Hey, there was this SLAT drafted by my former firm, and there's no provisions about divorce, which is very common because you can't really do that when you're doing this type of tax planning. Now they're getting divorced, and he doesn't want his future ex-wife to be the beneficiary anymore. Yeah, there's definitely, some downsides. So here's a handy little chart, to see what happens after the final judgment is entered. With respect to a power of attorney, the spouse's authority terminates upon filing for dissolution, like I mentioned. You don't have to wait until the final judgment. But for healthcare purposes, the authority doesn't terminate until final dissolution. So that's really important. Declaration of pre-need guardian, like Kristen mentioned. So this is if I become incapacitated and I need a guardian. The spouse is not necessarily completely disqualified, although Florida law says there may be a disqualifying conflict of interest because there is a divorce pending. Here again, last will and testament and revocable trust. The spouse's interest, including trustee or personal representative appointment, terminates upon final judgment for dissolution. So if something happens to you during the time the divorce is pending, which I'm sure Akilah can attest, sometimes these divorces take a while, that could be a huge issue if your soon-to-be ex-spouse is getting all of your money instead of your children or, someone else that you would want to receive it. And then again, same thing, beneficiary designations. Now, it's still really important to make sure that you're getting those reviewed, again, to make sure that there's no exceptions with respect to those assets. So here are just some things that we would, have you consider if you have gone through a divorce, or if you're about to get married, or if you are having a child. Make sure that you have a qualified estate planning attorney, at least reviewing your estate planning documents. We meet with our clients every year to make sure that we're capturing these various life changes. Although we tell our clients, look, if you're filing for divorce, getting married, having children, someone has passed, talk to us before, your annual appointment. But just making sure that you're getting them reviewed and then updated as necessary. Only a qualified attorney can tell you, here's what's going to happen based on your documents, how things are titled, and things like that. Update those fiduciary appointments to make sure that, the trustee is not someone who you're divorcing, or removing former spouse as a beneficiary, making sure the language is clear that they are removed, that you are divorced, and that they are no longer a beneficiary if that's what you want. And tax considerations and planning, now that you are divorced. Something that also comes into play that we've seen over the years with prenuptial agreements are things like, if you're a high net worth individual, the ability to share with your tax exemption. What are you going to do about that? Is that going to be, that can come into play within your prenup or postnup? How you're going to file income tax returns, how you're going to file with respect to estate planning. Are you going to require that certain things go into an estate plan, or that certain assets that are not marital property, typically like an inheritance, are segregated? All of those things go into that agreement, which is why, we really wanted to sit down and talk to you